have heard a lot of criticism this past year about activist judges, and especially when they issue opinions dealing with the rights of same-sex couples. We like to think of them not as activists, but just doing their job, interpreting the Constitution to protect the rights of minorities. We have one of those judges who has done a great job of doing his job with us today to give this year's keynote address. Former Chief Justice of the Vermont Supreme Court, Jeffrey Amestoy. The Honorable Jeffrey Amestoy was Attorney General of Vermont from 1985 to 1997. In 1997, he was appointed by then Governor Howard Dean to be the Chief Justice of the Vermont Supreme Court. Among many notable decisions, in 1999, he authored the opinion in Baker v. State, which said that same-sex couples in Vermont must be extended all the rights of marriage, which led to Vermont's civil union legislation. Currently, he's a fellow at the Institute of Politics for Harvard University. So please join me in welcoming Justice Jeffrey Amestoy.
Thank you very much. Thank you for that warm introduction. There are some who've been less generous. Shortly before I left the bench, I attended a reception where an attorney, undoubtedly aware that I still had cases under advisement, said to my spouse, "You must be very proud of your husband. He will go down in history." Yes, she replied, "Is Mr. Separate but equal?" So I'm grateful to the Williams Project and the UCLA School of Law for extending to me the opportunity to speak with you today. This represents one of the first occasions that I've had since resigning the position of Chief Justice last August to reflect on Baker, Vermont case, and its aftermath. Even while I was Chief Justice, my colleagues reminded me that my perspective was not necessarily theirs. So it may be helpful to keep in mind a story recounted by the physicist Freeman Dyson. A fellow physicist once announced to Dyson that he was going to keep a diary. "I don't intend to publish it," said the physicist. "I'm merely going to record the facts for the information of God." "Don't you think God knows the facts?" Dyson asked. "Yes," replied his friend. "He knows the facts, but he does not know this version of the facts." So this is my version. The relevance of my observations about same-sex marriage claims rest on two assumptions. The first is that it is unlikely, given the current composition of the United States Supreme Court and the likely composition in the immediate future, that an opinion of that court will recognize a same-sex marriage claim. An advocate asserting a constitutional claim to same-sex marriage would, I think, want more favorable conditions than is in the immediate forecast, where the outlook is at the very least unsettled. That leads to my second assumption, that there will continue to be, as there are today, for example, in California, New York, and Washington, significant state constitutional cases that will impact the future legal, political, and social discourse surrounding the issue of same-sex marriage. My premise, then, is that there is some benefit for those invested in the success of same-sex marriage claims in recognizing the difference between the state constitutional context and the federal constitutional context. I've chosen the word context deliberately because what I seek to emphasize today is not the substantive legal distinction between state and federal constitutional same-sex marriage arguments, but rather the profoundly distinctive constitutional culture in which state Supreme Courts are situated. I was a student at Hastings Law School up the road a piece, and when I was there, it was certainly true that the study of constitutional law was entirely predicated on the federal model. Notwithstanding the 3 decades plus since of the new judicial federalism, most lawyers, and judges too in my experience, are hardwired, if you will, to the assumption that the ultimate authority of constitutional interpretation is judicial authority. Thus, in the words of Chief Justice John Marshall, in Marbury versus Madison, the Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts, is alterable when the legislature shall please to alter it. Between these alternatives, there is no middle ground. Although a decision of the United States Supreme Court may be overturned through the constitutional amendment process, that event is exceedingly rare in American history. Of course, on one of the 4 occasions, it literally took a war to supersede Scott versus Sanford with the 13th Amendment. It is not altogether surprising then to see the difficulty confronting those who seek to amend the United States Constitution before there is a decision to overturn it. But John Marshall's historic and fundamental explication of the federal Constitution and the history that has flowed from it is not entirely applicable in the context of state constitutional law. There is, in fact, a middle ground in state constitutionalism, occupied by the institutional and organizational context of state constitutions and of the state appellate courts with the responsibility to interpret a state constitution. I don't mean to suggest that state constitutions themselves occupy a middle tier between paramount law and mere legislation. Instead, I use the term to describe the process that enables the alteration of state constitutions with much more flexible mechanisms than the process needed to amend the United States Constitution. It is understandable why advocates who successfully advance a state constitutional claim, to say nothing of the justices who author an opinion recognizing the claim, are reluctant to minimize the authority of judicial interpretation. It is worth noting, however, that an independent examination of the capacity of the judiciary to unilaterally determine the meaning of state constitutional provisions implicated in state constitutional same-sex marriage claims, and written, I might add, just prior to the Vermont decision, concluded, and I quote, "In settings of popular constitutionalism, judicial determinations of controversial state constitutional rights and meanings are rarely final. Instead, popular determinations of the context of those rights will more likely prevail, even if the process is politically messy and controversial." For those for whom judicial authority is seen as ultimate authority, it may be difficult to accept the role of non-judicial actors in state constitutional issues. This is, of course, particularly true when one applauds the result reached by the judiciary, but is less enthusiastic about the potential outcome of a non-judicial constitutional process. Authors of well-crafted constitutional opinions, like architects of finely designed houses, may not see the virtue of laypersons' alterations of either the opinion or the house. And in fact, neither the architect of a fine house nor the architect of a constitutional opinion of the United States Supreme Court has to be much concerned with immediate modification of the result. But as the owner of a much modified farmhouse and as the author of state constitutional opinions, I've been struck by the similarity between popular architecture and popular constitutionalism. In a small masterpiece of architectural scholarship by Professor Thomas Hupka entitled "Big House, Little House, Back House, Barn, the Connected Farm Buildings of New England," he observes that buildings are seen as an expression of their culture. Professor Hupka is, of course, not contrasting the study of federal constitutionalism to state constitutionalism, but his insights about popular architecture resonate. And I quote, "The term popular is used here to mean the buildings that most farmers made most of the time. Architectural orthodoxy has usually chosen to examine the houses of the region's wealthy classes and neglected examples of popular architecture. Unfortunately, data from those studies has often been applied inappropriately to the analysis of common farmhouses. Douglas Reed, to whose theory of popular constitutionalism I've already referred, finds a similar flaw in the orthodoxy of constitutional interpretation, which has attempted to apply insights gained from the examination of the federal Constitution the house, if you will, of a wealthier class, to state constitutional opinions. If one seeks to establish the relationship between the built form and the idea that generated its making, writes Professor Hupka, farmers must be seen as active participants in the design and building of the farmsteads. Similarly, observes Professor Reed, those who seek to understand the relationship between state constitutionalism and the ideas that generate it must recognize that part of the distinctiveness of state constitutionalism lies in its indeterminate process of interpretation, a process often open to non-judicial actors. A process that is both untidy and indeterminate is not normally embraced by architects, nor professors of architecture, nor by justices, nor professors of constitutional law. Professor Hupka feels obliged to observe in defense of his study of farmhouses. Some will probably object to the designation of common farmers as designers, because faculties such as design making and aesthetic preferences are usually associated with architects. Professor Reed sounds a similar note. What does it mean to live in a constitutional order that is not exclusively limited by higher law constitutionalism? It means that constitutional interpretation is not reserved exclusively for judges. It is a notion that may disturb many lawyers, both practicing and academic. Reed cites the passage of a state constitutional amendment effectively overturning the Hawaii Supreme Court's same-sex marriage opinion. As Professor Reed observes of the Hawaii experience, the Hawaii Supreme Court's tremendous defeat at the hands of a majority of Hawaiian citizens did not stem from its institutional position as a counter-majoritarian body. Rather, its loss stemmed from its assumption that it alone could interpret the Hawaii Constitution and determine the range of constitutional discourse. The architects assumed that the house could not be altered by those who live in it. I understand that for many judges and constitutional scholars who view state constitutional claims through the prism of the federal construct, words like strategic or pragmatic are unsettling, for they suggest considerations not normally associated with judicial decision-making. That connotation was certainly in the mind of my colleague Justice Johnson when she wrote in her concurring dissenting opinion in Baker that the failure of the majority to grant plaintiffs immediate relief was, and I quote, an abdication of judicial duty. And no sentence of the Baker majority is more representative of my view of state constitutional authority than my response. The implementation by the Vermont legislature of a constitutional right expounded by this court pursuant to the Vermont Constitution for the common benefit and protection of the Vermont community is not an abdication of judicial duty, it is the fulfillment of constitutional responsibility. As I observed in Baker, Hawaii and Alaska were instructive, or ought to have been, to those who believed that a state constitutional claim to same-sex marriage could be resolved solely by the judiciary. Nothing since has altered my view that non-judicial actors, by which I mean the public and those who represent them, would continue to insist upon their prerogative to engage in a state constitutional process that provides citizens with as much authority as judges to define the parameters of the state constitutional texts used to determine same-sex marriage claims. As Professor Helen Hirschkopf has noted, state court decisions, because of the relative ease with which state constitutions can be amended, lack the finality associated with Article III review. Hence, she observes, a state court's constitutional opinion may be only the opening statement of a public dialogue with other branches of the government and the people. For better or worse, the perspective I've just described is one which shaped my approach to the claims of the plaintiffs in Baker versus State. When the opinion was first issued, it prompted, as decisions about controversial issues do, much comment. I initially took comfort in knowing that many who were very critical of the opinion had not read it. That solace was offset, however, by the realization that many who praised the decision hadn't read it either. Of course, and I hesitate to make this observation to an audience containing distinguished law faculty and promising law students, those with the greatest authority to influence the consequences that may flow from a significant judicial decision are generally those least likely to have read the opinion. That is worth keeping in mind if one accepts my premise, and I understand there are those who do not, that a court's judgment in a state constitutional case of profound legal, social, and political consequences is not the final word. It is then that words matter. By conscious choice of language and analytic structure, a court may either arrest or advance the public debate, especially in such highly charged issues as same-sex marriage. In the felicitous phrase of Professor May Kuykendall, the court rearranges the public vocabulary and either enriches or diminishes the register of public speech. The choice of legal analysis in Baker's majority opinion was not without critics, as a quick glance at the concurring opinions will reveal. After all, it could have been possible to reach the same conclusion by conducting the suspect class fundamental rights analysis so familiar in the federal context and used, although not always consistently, in analyzing claims under Vermont's Common Benefits Clause. As significant as my view that craft, logic, and pragmatism in state constitutional opinions may compel a different analytic construct than is appropriate in federal claims, was my belief that the rhetoric of suspect class fundamental rights analysis would be unpersuasive to those with extrajudicial authority to alter the result of the court's opinion. If, for example, an opinion premised on the rationale that gays in Vermont were a suspect class was likely to trigger a divisive legislative and public debate about whether the court had correctly concluded that homosexuals in Vermont were subject to animus and prejudice, one had to be supremely confident in the usefulness of federal constitutional doctrine to resolve an extraordinarily significant state constitutional claim. That I was not is evident in the test adopted by the Baker majority, which rejected the suspect class fundamental rights test in favor of a more flexible weighing process, one which requires a case-specific analysis to ensure that any exclusion from the general benefit and protection of the law bears a just and reasonable relationship to the legislative goals. The rejection of the federal test enabled the majority to state the artificiality of suspect class labeling should be avoided, whereas here the plaintiffs are afforded the common benefits and protections of Article 7, not because they are part of a suspect class, but because they are part of the Vermont community. When a court does not have the last word in constitutional interpretation, the first words count. By expressing the view that acknowledgement of plaintiff's claim is, when all is said and done, a recognition of our common humanity, the court sought not merely to summarize a judicial opinion, but to give voice to a constitutional value that would resonate with Vermonters who had the power to change the Constitution and who would be urged to do so by those who were displeased with the Baker decision. I don't wish to be misunderstood, but by my emphasis on the lack of finality and the significance of language as minimizing the impact of a state constitutional judgment on the status quo. A Cambridge colleague of mine tells a wonderful story of the moments after midnight when the mandate in Goodrich, the Massachusetts case, went into effect, and hundreds of same-sex couples were lined up at Cambridge City Hall waiting to obtain marriage licenses. Included within that line was an opposite-sex couple also seeking a marriage license. A police officer approached the couple and informed them they would have to leave. Same-sex couples immediately objected, and the police officer retreated to confer with his superiors. He returned to tell the couple that he'd been mistaken. The clerk also had the authority to grant marriage licenses to heterosexual couples. So I don't underestimate the power of the law to change behavior. But I need not remind this audience that fundamental alteration of institutions and beliefs is never instantaneous nor easy. In Annapolis, Maryland, in front of the Old Court of Appeals, there's a remarkable statue of Thurgood Marshall. It's not a depiction of Marshall the judge, whom we see in our mind's eye as the heavy-set, sedentary figure of the United States Supreme Court, but of Thurgood Marshall the advocate, striding purposely away from the courthouse to his next legal battle. And the greatness of the sculpture is you can see that determination and you can feel that purpose. The statue is intended not only to honor the life of Marshall, but a moment in time. His successful argument before the Maryland Court of Appeals in the 1936 case of Murray versus Maryland, in which the court ruled that the state must desegregate the University of Maryland Law School. There are two historical ironies in that setting. The first is that to place the statue of Thurgood Marshall in front of the Court of Appeals, the statue of Chief Justice Roger Taney, a Maryland native and author of the Dred Scott opinion, was moved out of sight of the courthouse. The second is, although Marshall won Murray versus Maryland, he considered it a setback because it was the University of Maryland Law School case that Marshall had hoped would put before the United States Supreme Court the separate but equal issue, a day that we now know was almost 20 years away. It is that second irony of history that offers lessons for us today, not all of them to our liking. It may well be, in fact, as a matter of both personal belief and historical faith, I believe it will be, that another Marshall, Chief Justice Margaret Marshall of the Supreme Judicial Court of Massachusetts, will be as vindicated by history as Thurgood Marshall. But I respectfully suggest it would be a mistake to equate faith in the verdict of history with the capacity of a court alone to deliver that verdict, or to expect that verdict soon. The response to the judicial rearrangement of same-sex relationships will either enrich us or diminish us as individuals, as a community, and as a country. The future architecture of same-sex marriage will depend as much on those who inhabit the house as those who design it. We will know we have built well when, in the words of the poet, one can say of every constitution, underneath that roof there is no distinction of persons, but one family only, one heart, one hearth, and one household. Thank you.
I want to acknowledge the good work of the people here, of Bill and Brad and Chuck Williams' generosity, and all of you who are being supportive. This really is very important. 20 years ago, a project like this probably wouldn't have made a great deal of sense, because you would have done a lot of research and we wouldn't have known what to do with it. That is, there would have been a lot of good ideas, but we wouldn't have had the clout to put them there. I am firmly convinced that 20 years from now it won't be necessary. I think we are in a very pregnant moment in American history. I think we are on the verge of breaking the back of this vicious, debilitating prejudice that has blighted so many lives and continues to bite them. And we need to take the historical perspective. Clearly, things have come a long way, but I always stress when I note that we have made an enormous amount of progress that no one should expect us to be grateful because there is now less of a vicious and unfair prejudice than there used to be. George Orwell was shot in the neck during the Spanish Civil War. And when he recovered, someone said, "Boy, you're very lucky. You were shot in the neck and you recovered." He said, "Yes, but I think all the people who were never shot in the neck in the first place are even luckier than I." And I think this is the case. It's important to measure the progress we've made, not to be grateful. There are still 15-year-olds in this world whose lives are being made miserable by other kids and who aren't being protected by adults. And there are working people who are gay or lesbian who can't afford health insurance. And there are the tortured situations of couples in love of different nationalities who can't live together. There's a whole lot of problems. We have a lot to keep doing. The reason to look at the progress, though, is to figure out how did we get here, what worked and what didn't work, so we know what what works in the future. And I want to talk about that specifically with regard to same-sex marriage. First of all, let me quote my colleague. I met somebody here from Worcester, Mass. My colleague Jim McGovern from Worcester had a great quote last year in November. People said, well, what about all these states that voted against same-sex marriage? He said, no, only one state in America voted on same-sex marriage last year. That was Massachusetts, because we're the only state that had it. 11 other states voted on people's distorted fears of same-sex marriage, and there we didn't do well. But in Massachusetts, and this is very important for people to know, same-sex marriage was instituted in May. By the way, one thing about same-sex marriage for which the academic community, not necessarily here, should be grateful to us, and also stand-up comics should be grateful to us, because we have validated a central premise of their routines over the ages. A disproportionate number of the couples who have taken advantage of the same-sex marriage law in Massachusetts are, of course, women. Women have got married more than men. And what we have been able to prove is something that heterosexuals could never have proven on their own, that with regard to marriage, there is no gay-straight difference, there's a male-female difference. For a variety of reasons, in America, women are more interested in getting married than men. Now, stand-up comics have been claiming that for years. We proved it for them. Obviously, there are a whole lot of reasons for it, certainly including economic vulnerability, but that's still the fact. But here's what happened in Massachusetts. Our Supreme Judicial Court voted to allow same-sex marriage. It went into effect in May. At that point, conservative forces in Massachusetts decided to make this a big issue. Our Republican governor decided that this could be a way that he could make real gains in the legislature because, while it wasn't a strict party line vote on same-sex marriage, overwhelmingly those who voted, a constitutional amendment that would have banned same-sex marriage got a very narrow majority, 7 or 8 votes out of 200. And it was predominantly party line in our side, not entirely. So he figured if he could go after some Democrats who voted for same-sex marriage, he could get more Republicans, and he would get credit nationally because he's running for president. And what is clear now, if you are a Republican and you are running for president, civility is a clear disadvantage, and sanity don't help. So he decided he would have to go and take credit for defeating Democrats. The Catholic Church sadly joined in. There were a number of Democrats who represented heavily Catholic districts which were seen to be vulnerable. And we had an election campaign in which a significant issue was how people would vote on same-sex marriage. A group called Mass Equality sprung into play to help defend those legislators, did good fundraising. Frankly, it was serendipitous for me because if John Kerry had been elected president, I was going to be running for the Senate. And while we'll never know exactly what happened, in the words of Marlon Brando, I could have been a contender. But frankly, it turned out for me to be this great way of campaigning because I told Mass Equality I would obviously want to help any way I could. So I was in about 18 or 20 legislative districts doing fundraisers and campaigning for legislators who would support same-sex marriage, particularly in areas where they thought it might be a problem. So we had this campaign in Massachusetts on the reality of same-sex marriage. And every single legislator who voted to allow same-sex marriage to stay was reelected. 2 incumbents were defeated in Democratic primaries. There were incumbents who had voted against same-sex marriage who were defeated by people who were in favor of it. We will have a couple of special elections soon in which a couple of opponents of same-sex marriage will be replaced, one for sure by a supporter and maybe another one not. The new speaker is supportive. What's going to happen is at some point this year in Massachusetts, after over a year of same-sex marriage being a reality and an election campaign in which people challenged it, the legislature of Massachusetts is going to vote to keep same-sex marriage. That's very important for a couple of reasons. First of all, it will make it hard for even George Bush to claim that what he's fighting is judicial activism. Because, in fact, what we will have is a democratic process, an election and a legislature elected thereby voting in favor of same-sex marriage. So that's the good news for Massachusetts. Essentially, and I wish, here's a project. It's not that tough intellectually, but it takes a little work. Maybe you get an undergraduate who wants to, start out doing research. Go back on every single anti-discrimination issue we have ever passed dealing with gay, lesbian, bisexual, or transgendered people, and read the objections of the opponents, particularly read their predictions. And nobody ever does this. Every time we talk about making discrimination in some cases illegal, the bigots say, well, we don't have anything against these people, but here are the terrible things that are going to happen. And none of them ever do. And they get away with it. No one ever goes back and says, well, here were the predictions, and here's the reality. I remember when we did the Americans with Disabilities Act, and it protected people with AIDS. And we had tough fights about that. An amendment that went through and had to be reversed to say you couldn't work in a restaurant if you had AIDS. People made all of these terrible predictions. One, I remember one of the nuts, Falwell or Robertson, or one of them said, well, if this bill passes, they're going to have to start hiring gay people in churches. Great old Democrat from North Carolina, Bill Hefner, said, well, who the hell do they think's playing the damn organ? But we need to go back, and I really recommend this academically, go back and see what they say, and it is always untrue. And of course that happened in Massachusetts. I mean, it is quite literally the case, as we expected, the only heterosexuals in Massachusetts who have been at all affected by same-sex marriage 10 months into it are people who lived across the street from a couple of lesbians and felt the need to buy them a present. Those are the only ones who've had any effect whatsoever. Nobody thinks about buying the guys presents. And what's happened is reality has won. Now, that's where we are. So then the question is, what's the lesson from that? Now, before I get into some specifics, I want to defend a basic principle. I mean, people said after the election, there was a lot of controversy. I thought that the mayor of San Francisco, the mayor of New Paltz, New York, the people in Oregon and the people in New Mexico made a mistake, although I was appalled to see that they have reinstated the criminal complaint against the mayor of New Paltz, New York, who I guess is guilty of conspiracy to commit. That appears to be the crime in New York, by allowing people to marry when the law doesn't allow it. But I want to talk about whether or not we make these kind of judgments. There are two groups that I think have gotten it wrong with regard to same-sex marriage. Those of us generally on our side. I have some of my Democratic colleagues who are generally supportive of equal treatment for gays, lesbians, bisexuals, and transgender. And let's be very clear. You can't talk about equal treatment and leave out something as important as marriage. I mean, it's just not arguable. You're either for equal treatment or you're not, and if you are, then it's the full range of equality. So I've got some people on the Democratic side who were gun-shy after the last election, and they want to stop trying for a while to achieve same-sex marriage. And they're wrong. But some of our own, I think, make another mistake, a lesser mistake. I don't equate them. But while there are some people who want to stop trying to achieve same-sex marriage, we've got people who don't want to think about how to do it. And I mean think seriously about how you do it. And not simply say, this is wonderful, let's go out there. And one of the great historical errors I've encountered are people who say, well, you know, let's follow the civil rights movement. And the civil rights movement, they didn't stop and think and worry. They just went out there and did it. The hell they did. You know, it is disappointing to me that at a point when our community has sort of begun to celebrate one of the great heroes of the gay community in American history, Bayard Rustin, a man who was as responsible for civil rights progress as anybody else and was penalized for his gayness, and we now celebrate it. But people repudiate his whole raison d'etre. Bayard Rustin was one of the smartest, shrewdest strategists and tacticians. And he spent a lot of time saying, let's do this, and a lot of time saying, oh God, let's not do that. And people say, oh no, whatever is good, I mean, people have said, whatever is affirming of our rights, you do it and you don't question it. And that's like the civil rights movement. In the summer of 1964, I was in Mississippi as part of the Mississippi Freedom Project. It was run by all the civil rights organizations, SNCC, CORE, the NAACP, the Urban League, the Southern Christian Leadership Conference. And while we were there, that, you remember, was the summer when Cheney, Schwerner, and Goodman were murdered. And we got there in June. And on the 4th of July that year, Lyndon Johnson signed the 1964 Civil Rights Act, so that segregation was now illegal in Mississippi, as in the rest of America, at lunch counters and motels and movie theaters. And Martin Luther King and Stokely Carmichael and James Farmer and everybody else said to those of us, the young volunteers, stay the hell away from the lunch counters and the movie theaters. We had a legal right to integrate them. But they said, we're here to deal with voting rights. We're here to show America that black people aren't even allowed to vote in Mississippi. We're here to put together a delegation to go challenge at the Democratic Convention. We do not want to get diverted into a side issue. Because while people supported the right to eat lunch, the right to eat lunch was not seen as important as the need to vote. And they did not want to distract us. So we were ordered not to take advantage, in effect, voluntarily to abide by segregation that had now been illegal. Go back to the March on Washington in 1963. John Lewis, one of the great moral heroes of our time. And I got to say, when people question whether or not, for me and others, being in the Democratic Party is the best way to achieve social progress, I give them the example of John Lewis, our Chief Deputy Whip, the moral exemplar of my generation. A man who was almost beaten to death on a couple of occasions and kept going back for more. And in 1963, at the March on Washington, he submitted to censorship of his speech. Censorship that was done, by the way, by Bayard Rustin, acting under the authority of A. Philip Randolph. Because they said, look, we're trying to win this thing. And we're trying to win support in the country. And you say some things and you don't say others. So when some of us say, you know what, if we're having a march, now there are two possible, I guess there are three reasons for a march. One is exercise, but we got gyms. You don't really, it's not very efficient. Another is to express your feelings. And the third is to try and influence the people who are in the middle. Forget the enemies, you can write them off. Why is it wrong if you are having a demonstration, the stated purpose of which is to influence public opinion, to take into account public opinion? And it's somehow argued that, look, we're going to go out there and demonstrate, we're not going to do all this strategizing. Well, then what the hell are you doing it for? I mean, I have a rule. I've said this before. Look, Mark Leno is here. Mark will understand this. We're not in our districts. Mark, we can be honest about this. I never lie, but you don't always volunteer the truth. I mean, actually, you should understand. Mark and I are already undergoing a little bit of separation anxiety because Brad is up here raising money and we're not going to get any of it. We're not used to this. But whenever you hear a candidate for office tell you how much he or she enjoys campaigning in a tough race, please understand that you're listening to either a liar or a sociopath. There is nothing fun about campaigning for office, in my judgment. And in fact, much of politics isn't fun. It's not supposed to be fun. It is hard work. And in a lot of these things, if you are really having a very good time all the time in your political activity, you're not doing the right thing. Because part of what you're trying to do is to figure out how to influence people who are on the other side. And so I think it ought to just be axiomatic. You take into account what people think. Now let me translate that to marriage. One of the things that seems to be very clear, we learned this last year. The only significant way to get people to change their opinion in large numbers about the desirability of same-sex marriage is to implement it. Now, there's a kind of a chicken and egg problem here, I understand it. But I think there's an answer, and I think it has to do with the interaction of law and politics. We have seen this in area after Vermont. Vermont was split open by the debate over civil unions. Now it's boring. Some women told me this. They were in Vermont and they came across a barn, and painted on the side of the barn was the slogan, "Take Back Vermont," which was what the anti-civil union people had said in 2000. And they wanted to bust them. So they went up to the farmer whose barn it was. They said, "Oh, what does that mean?" And he said it had to do with opposition to hunting. I mean, he didn't want to tell the truth. And that's very important, by the way, because I mean, it's a very important statement from the French writer La Rochefoucauld. Hypocrisy is the tribute that vice pays to virtue. When people are lying in a political campaign, it means that they know that if they told the truth, they would get hurt. Because, look, leaving aside morality, if you're in a political campaign, you'd rather tell the truth than lie. It's easier to tell the truth. I mean, if somebody's lying about me in a political campaign, that's easy. I know what to do. It's when people tell certain truths about you that you really have to scramble and figure out what you're going to do. That's when your consultants earn their money, when people are telling the truth about you that you don't want anyone to know. But we see this everywhere. Same-sex marriage is terribly controversial until it goes into effect. I think that's because there are two groups of people who are against us. One are the bigots. They don't like us. And if you don't like one lesbian, the thought of two of them hanging out makes you really upset. I mean, that's basically, that's all it is. And it's geometric. They're not the majority. the majority is made up, the majority of the group that makes the majority are people who really are not anti anymore. And many of them are supportive on other things. But they hear the governor, they hear the minister, the cardinal, some other academic, et cetera. They hear opinion leaders say, you know, if you let those people get married, it's going to cause trouble. Now, remember, people don't live other people's lives. So, yeah, there are straight people who are very well-intentioned. They don't know what it's like. It's very hard to know what it's like. I don't know what it's like to be black. I think I'm very supportive of the civil rights movement, but I've never experienced it emotionally. I'd make an effort to try and reach out. Most people, they don't have the job I have. They don't have to try. So people don't live other people's lives. They say, I think this is the group we're talking to. They say, well, you know, I don't have anything against those people. There's no problem. But, you know, why do they have to get married? Well, we can take care of them in other ways. And I hear there could be trouble. And the most effective way to reach them is to implement it. Now, that becomes problematic. But I think what we did in Massachusetts is probably the model that we should be following. It may be different here in California. There may be a possibility of doing it purely politically. In most states and in most political jurisdictions, that's not going to be possible. But what I would think we do is this. If there is any way to get same-sex marriage implemented in a jurisdiction in which it will take them some time to undo it, that's the way we will win. I mean, what saved us in Massachusetts, if they had voted in Massachusetts on same-sex marriage the day it went into effect, we would have lost. But under our Constitution, the earliest vote could have been in 2006. Now it's probably not going to come until 2008 because the legislature is going to say no. They'll have to start all over again with a petition. By that time, people are going to be pissed off at them for bothering them about talking about it. It'll be such a boring issue. But that's why the lawsuit in New York. I mean, there's no point in trying to win a lawsuit in Mississippi. But I guess there's a certain kind of reinforcement here. In those states where we wouldn't be able to sustain it politically, we probably can't win it in court anyway. But the ideal would be to win lawsuits under state constitutions in those states where we would then have a year or more, and I believe that's the model by which we will then get same-sex marriage. We'll get it in New York, maybe we'll get it in New Jersey. So you get good governors who appoint good Supreme Court justices, and that is the way it will happen. But that to me means proclaiming same-sex marriage when you can't implement it does not help. And I do not think, and another thing that they did in Massachusetts that was very sensible. In Massachusetts, they made a deliberate effort. There were no large gatherings. Let me just put it this way. I think we are better off leaving mass marriages to the Moonies. They haven't done them a lot of good, and I don't think they do us a lot of good. I think what we're trying to say is, look, men and women who are gay or lesbian want to get married for the same reason anybody else does. They want to get married because they love each other and they're committed to each other and they want to be financially and legally as well as morally responsible for each other. And you don't have mass marriages. I don't think they add anything, and I think they made a conscious effort in Massachusetts not to do that, and I think it worked well. So that's the model, it seems to me. And you take the model of Bayard Rustin and the civil rights movement. I wish, and people who think, oh, anything you do that's if you feel good, do it, is not very good political activity. Politics ain't therapy. The purpose of political action is not to make you feel better or to express your frustration. You're aiming at mobilizing your own people, trying to move others. The model that clearly works in same-sex marriage is the one that we kind of stumbled on in Massachusetts. But I think there's a chance in New York, there's a chance in New Jersey. Evan would know better than I where the other states are. But in those states where we can get a Supreme Court to implement, and that's why people have said, I think people are wrong who say, oh no, don't try and do it by a court, try and do it politically. In very few jurisdictions will that be possible. And by the way, that's also the lesson of the civil rights movement. The NAACP had a long history of opposing referenda with regard to civil rights. In the history of the civil rights movement was also, you win it in court first, and then you win it in court, you experience the reality, and then you defend the reality, because at that point you have disarmed the crazy arguments. And that's the model that we ought to be following. It is, as I said, to go to those states where it makes sense. Now, there are some corollaries to that, or some lessons from that. One is, and I think we've come to a consensus on this in the movement, no matter what people think the full faith and credit clause should mean ideally, if we ever got a federal, not ever, but if in the next several years, the Supreme Court of the United States were to decide that the full faith and credit clause applied, and marriages in Massachusetts had to be recognized everywhere in the country, we would lose the constitutional amendment. I wish that weren't the case, but we are not yet ready to win that. That is and I wish there were more people ready to stand up and say, we're for marriage because we're for it. We're not yet there. I think we will get there, and we will get there the more and more people who experience it. But I think there has been this consensus in our community not to try and push the full faith and credit argument. I don't think it would win anyway. I must say, the very fact, I believe, that they had to bring the Lovings case, the integration case, I mean, the case that said states could not ban interracial marriages, which was a 14th Amendment case, not a full faith and credit case. If full faith and credit applied, you wouldn't have needed the 14th Amendment. Two people could have gotten married in New York and gone to Virginia, and Virginia would have had to recognize it. They wouldn't have gone to Mississippi unless they were just wacky, because the thugs would have murdered them and the cops wouldn't have done anything about it. I get just in '64 summer, Mississippi. One thing that sticks in my mind: they had made a big breakthrough. They had allowed black police officers, but the black police officers were not allowed to arrest white people. Black police officers could only arrest black people. And while we were there, a black guy and a white guy got in a fight, and a black cop showed up, and he could only arrest the black guy and not the white guy. It was, people forget how bizarre it was. But as I said, I think we have decided to give up on full faith and credit and not make that argument. Because if we did, we would lose the political fight and we would get locked in prohibitions against same-sex marriage. Now, if it didn't make any difference if we had it, that argument, then we might as well go for full faith and credit. But I really believe very, very clearly, as I said, it's the interaction of law and politics. What we need is for the lawyers to pick those states where we can win the case, where you have a Supreme Court that's reasonable and a good constitution and language you can win with, and make sure that, and hopefully they would be states where the process for overriding the state's constitution is such that you have a time period. And if we keep doing this, I think within 6 or 8 years we can have 4 or 5 states. At some point we'll reach critical mass, and then we will be able to go forward. So that means giving up on full faith and credit as an argument. And it means, I believe, not having marriages that aren't marriages and saying we're going to do it anyway. By the way, I think that was part of the reason, and as some of you know, I was not in favor of what they did in San Francisco and elsewhere. Misinterpreted. It wasn't because I was worried about the effect on the election. I was worried about the effect on same-sex marriage. I was worried that it might produce more votes for the constitutional amendment. By the way, we should also say a small thanks to the right-wingers, because if it weren't for the right-wingers, they could probably get through the Congress today an amendment that simply got rid of full faith and credit, for sure. But people said, don't mention it, but don't worry about it. They're much too crazy to do that. They will not do that, because an amendment that says there is no full faith and credit implicitly says you can have it in one state. I mean, in some ways, I guess I almost feel like I'm channeling Lenin here, which, I mean, on a wholly unrelated issue, I would tell you, I am convinced one of the big problems in America today is that Paul Wolfowitz, the Deputy Secretary of Defense, has been channeling Trotsky for some time. Paul Wolfowitz is Trotsky with somewhat better morals but much worse judgment, and that's been a big part of our problem. But I mean, there were two Lenin tracks that seem to me relevant. One is Socialism in One Country. Remember, Marxism was to be a universal doctrine, and when it looked like they weren't going to be able to get much beyond Russia, Lenin redid it and wrote the justification for socialism in one country. For us today, it's marriage in one state at a time. You get marriage in a state, you defend it, you have the reality, and then it spreads. The other thing that I would invoke was Lenin's, and it has to do with my view that you don't think about things, you just go forward, you just do what feels good. He wrote another pamphlet called Leftism and Infantile Disorder. And I would hope that people would keep at least those two things in mind. That is, no, we don't stop trying to get same-sex marriage, but we think hard about doing it. Let me just close with this, I'm a little late. I'm a great believer in free speech. I repented last year. Worst vote I ever cast after the Janet Jackson, Tim White thing. I wasn't paying attention. I voted for that indecency fine thing. This year I was glad they brought it up again, so I got to vote against it, particularly after the Secretary of Education decided that if a mechanical rabbit knew that there were lesbians, this would be the end of civilization as we knew it. And I noted that when they began to censor that, one of the things they had apparently decided was that references to gay or lesbian or bisexual or transgendered people were inappropriate except at very odd hours. So I asked whether, if that were to pass, if in the future I would be bleeped from C-SPAN. I thought maybe when I spoke on C-SPAN they would have to kind of get rid of me. So I'm a great believer in free speech. But I would like to make it a misdemeanor to use the words pragmatic and idealistic as if they were somehow opposites. And I'm going to close with this. It's not a chicken and egg thing. You start with the idealism. I'm in a business, Mark's in a business where ultimately, if you don't do what we say, if enough of us say it, people with guns will come and make you do it. That's a pretty solemn responsibility, and I don't think you have any right to get into that unless you are really motivated by genuinely deep moral convictions. You're trying to make this a better and fairer world. So you start with the idealism. But once you have selected your ideals, the notion that you don't be pragmatic about them is appalling. Isn't it clear? The more strongly committed you are to your ideals, the more you are morally obligated to be pragmatic about implementing them. What good do your ideals do if they're never implemented? I mean, no ideal ever protected some 15-year-old lesbian from getting beaten up in high school, or helped some working-class guy not be fired, or helped some old woman get health care, or cleaned up a river. I mean, unrealized ideals make you feel better. They don't help anybody. And this notion, I've had people say to me, well, you're being pragmatic, I'm being idealistic. Your ideals, if you're serious about them, require you to be pragmatic, i.e., if you care about these things and help implement them. We can have debates about what's the best way to do it, but the notion that it's somehow illegitimate to have that debate is just nuts, and it's the best favor for our enemies. But in this case, I do think we've managed to come to a consensus. Let's win these lawsuits where we can. Let's then defend efforts to undo it after we have had the reality. And to the extent we can do that, we can win. So that is the longer-term optimistic scenario, and I'm feeling pretty good about it. Thank you.